I was honored to be able to appear before the Senate committee when this bill was Bill C-6. It was actually a pleasure to be able to share my concerns and also to address the questions of the senators that were directed towards me. I have to say, though, that I was a little surprised that the questions, whether they were kind of pro or against what was then Bill C-6, fell across party lines. And it concerned me just simply because of the nature of my presentation. I wasn't before the Senate to say there isn't room for us to improve our safety legislation. I was addressing concerns that we were undermining the rule of law, which literally is the major underpinning of any liberal democracy. That I was concerned that we were going to allow the state to take control over private property without the supervision of independent courts or an independent body like the Review Board under the Hazardous Products Act. My concerns about the rule of law, about even the constitutional underpinnings of this type of legislation, is not the type of thing in my submission that should go along party lines. My concerns are actually the types of concerns that the Senate is supposed to be addressing. I actually find it very ironic that recently the Senate has been criticized for voting down a bill that was passed by the House of Commons, and the criticism being, well, the Senate is unelected. And as somebody who has studied the Constitution, I find that very curious, because the Fathers of Confederation very deliberately chose to have an unelected Senate, fully appreciating that it was not going to be often that the unelected Senate would fail to approve a bill sent to it by the elected House, but at the same time recognizing that the elected House is subject to re-election, is subject to the will of the people at the time, which can also be influenced by populist concerns and can also just simply be making bad policy for any number of reasons. And yet the elected Senate, though, their strength is that they're appointed. Their strength is that senators don't have to worry about re-election, can actually look at legislation with a long-term view and ask the question, is this good for Canada? And in the case of something like Bill C-36, where other legal experts, not just myself, have voiced the alarm and said we are concerned that this is undermining some fundamental legal principles that Canada is based on. This is the type of situation where the Senate, being unelected, is in a position of strength and can sit back and say, well, let's have a hard look at that. Let's address these concerns without any concern about party politics, because it's exactly when legal foundations, such as the rule of law, are being challenged, that the Senate is expected to step in, that the Senate is expected to intervene and ensure that those types of things aren't undermined. So it actually very strongly encourage all senators, regardless of party affiliation, to educate yourself about the concerns that are being voiced by legal experts, to fully understand that this does undermine the rule of law, that it undermines property rights, and to simply ask questions like, can you give us actually real examples where Canadians were put at risk under our old law, which respected the rule of law? Give us some examples and explain to us, well, why court injunctions and ministerial orders and search warrants and things like that supervised by the court can't protect Canadians. Because there's a danger in and of itself whenever you allow the state to act in an arbitrary manner, that is without supervision, towards the citizens.